Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Welcome to Legally Speaking with Melanie van Orde, brought to you by Aitken Robertson Criminal Law. I'm Melanie, and today's episode is an insightful discussion with counsel Richard Aitken, the managing lawyer at Aitken Robertson. In this episode, Richard will shed some light on a critical topic. Can victims drop the charges? We will explore the complexity surrounding this question, including the role of victims in the legal process and how their decisions interact with the prosecution of criminal cases. So join us today as we deep dive into an important subject and gain a better understanding of the legal intricacies involved. Stay tuned for this enlightening conversation. Richard, can a victim have the charges dropped after a person has been charged?
No, it's not up to the victim. It's up to the Crown Attorney. The victim complains, the police investigate, the Crown Attorney prosecutes. So it's within totally the discretion of the prosecutor. However, the viewpoint of the victim does matter, and often the Crown will take that into consideration. One of the main factors here, what we have to decide at the start, is looking at the police report. Was there a KGB video done? Now, this is not the former secret police of the Soviet Union. It's the name of a case called KGB. And in that case, it stands to the proposition is where the victim has done a sworn statement by video or audio tape, that evidence can be used even if the victim decides not to testify. So certainly, if there's no KGB statement, the accused is in a much better position than if there is a KGB statement.
And Richard, let's say there is a KGB statement. How would that impact the charges going forward?
It's more difficult for the accused, certainly. I think what the starting point is that when there's a complaint and one spouse calls the police on the other spouse, it's like an avalanche. And once the avalanche gets started, it's hard to stop. Very, very difficult. And in the heat of the moment, people have regrets. The next day, one person thinks, I wish I had not called the police. I wish we had simply talked about it. But once the call to the police is made, the police investigate, they have very little discretion, and typically there's a charge. Now, often the police, when charging a person, don't think it through. They release the person on certain terms, and often the terms are sloppy and need to be amended. For instance, in a family situation, when there's a couple of kids, perhaps, the usual term is not to have any contact, direct or indirect. Well, obviously, the spouses still need to talk about who's picking Bobby up from school, who's bringing Jill to the movies, who's paying the hydro bill this month, who's paying the mortgage. That's the reality. So one of the first things we do is we look at the release terms and figure out what sort of a release term variation might be appropriate.
So, Richard, in a situation where there was a KGB statement made by the complainant, how will that impact the accused case moving forward?
Well, if there's no KGB statement and the person who has complained, the spouse usually, who's called the police, they often have second thoughts and decide they're not going to testify or cooperate. The reality is it's unlikely there could be a successful prosecution in that case. However, where there is a KGB statement, it changes things. More work is involved. Often we could convince the Crown to drop the charges or reduce it to a peace bond so there's no criminal conviction, or even if the charge does proceed, that there be a discharge. So at the end of a period of time, there is no criminal record. Upfront work's often required. There's a course called PARS, where the accused takes that. And usually over the space of a number of weeks, various variations of the release terms take place to allow some sort of contact. Now, the reality is, while the complainant cannot drop the charges, as I said, what they say does matter. There's no history of violence in the relationship. The accused has no previous criminal record. The accused is willing to own up to what happened. Often things that can be done that allow the couple to resume the relationship at a future point in time.
Thank you so much, Richard, for joining us today and discussing whether a victim can drop the charges. And thank you to everyone else for joining us on the Aitken Robertson Legally Speaking YouTube channel. So don't forget to like, subscribe, and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged, and take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.